I want to talk today about mitigation, about what mitigation is, and also about what mitigation is not. I want to talk in particular with reference to military matters in regard to Major Ag 67 and court-martial or CO's summary hearing. However, a lot of the rules relating to mitigation can equally apply in the civilian context as well. So, what mitigation is? Mitigation is an explanation as to why a sentence should be less severe than might otherwise be the case. So, mitigation can be split down into two parts. Mitigation first concerns the circumstances of the offence, and second concerns the circumstances of the particular offender. Now, you will note in both those instances I've used the words offence or offender, and the reason for that is this. In mitigation, the individual has either accepted their guilt or has been found guilty or to have breached the service test in Major Ag. What mitigation is not, however, mitigation is not a defence to argue that an offence has not been carried out. So mitigation is used when an individual has either pleaded guilty or accepted that they failed the service test or has been found guilty following a trial, whether at court-martial, CO summary hearing, the civilian magistrates, civilian crown court, whatever. What mitigation is not, it is not an explanation to demonstrate that an individual is not guilty of the alleged offence. That is something entirely separate. So mitigation, it can be split into two parts. Mitigation concerning the offence itself, and then the mitigation concerning the particular individual. In the civilian context, there is the sentencing guidelines available for many offences that will actually list mitigating factors that make a sentence suitable to be less severe than would otherwise be the case. And there are also sentencing guidelines for court-martial as well. So the first step is to look at the sentencing guidelines to establish what areas may apply as mitigation to reduce the severity of the sentence. That concerns the offence itself. So just for an example, if an incident was a one-off, if the individual wasn't at that time on bail, those might be matters of mitigation reserved to the individual offence. More often, the mitigation may focus, having looked at the sentencing guidelines, there is the individual mitigation, so the individual's personal circumstances, and that could be a wide variety of things. It could be their health, it could be family matters, it could be education, it could be housing, it could be difficulties with some form of drug dependency or something of that nature. There is a whole raft of personal mitigation that can be used to demonstrate to a court that an individual's sentence should be less severe than may otherwise be the case. But mitigation itself is completely separate and distinct from presenting arguments to say or to put forward to demonstrate that an offence has not been committed. That is not what mitigation is. Mitigation is when either an individual has accepted responsibility, has accepted that they committed the offence, or has been found guilty following either a trial or guilty plea or something of that nature. At that point, that's when mitigation can then be presented.